Chinese mainland is said to be the greatest marketplace on earth, but being the greatest marketplace, it also comes with a great deal of risk. And talking risk, we're talking to Hong Kong law firm Oldham, Lee and Nye, and to partner Alfred IP. Alfred, really looking at the marketplace that we have in China and looking at the risk factors, what do you suppose will be those risks in legal terms? And how does the legal jurisdiction in China differ from all over the world?
Well, I would say that it's actually a very different system in the first place, because Chinese is more civil law system, which rely on a lot of code and statute, compared with the common law system, which we have a lot of case law and court decision to determine how the contract can be interpreted in the first place, etc. And it's a very different games, and it is particularly intimidating for foreign parties when they're entering into China and start doing business, because they don't understand how the game is played, which can be very different.
So does that mean that there's a lot more negotiation room where it comes to legal contracts in China?
Exactly. Actually, it's very interesting when sometimes the parties change the terms in the course of the performance of the contract. A lot of time people are just considering the establishment of a contract, the initial phase of the negotiation. And this is sometimes people will find it very hard to follow.
So if you're a buyer of goods, let's say toys, how do you ensure that those goods, those toys, are going to be up to standard if they're made on the mainland?
I would say that clarity is always the case, the keys. The best way to do is to make sure that your suppliers understand what you're asking for. For example, if there's a certain standard that requires the goods to be complied with, you provide them in the first place. For example, the EU standard, the CE standard, etc. And besides, it's always better to look at the samples first.
So would mainland suppliers really be up to date with what's going on in, let's say, the United States and in Europe on regulations?
My experience tells me that they don't, generally. They always say that they can do it, and they can do it on time, and they can do it at a very cheap rate. They can make any sort of promise to you, and they will not be up to date as to what exactly is required for goods to be sold. And at the end of the day, when you reject the goods, they will say that, oh, this is not common practice. This is not what we are aware of, and which we knew about these kind of requirements. We would not have charged you at that price or promised to deliver it to you in the first place.
So one would think that as a lawyer you'll be doing a certain amount of hand-holding with your client, but what about the opposite party on the mainland?
I wish I could do more hand-holding with our clients, but it's just that a lot of times a lot of deals are concluded very swiftly, and it seems that a lot of clients are just placing their order by fax, by emails, or just a phone call, and they do not have thought about the requirements that should be set out clearly in the email or in the fax or in the documents. And at the end of the day, they are in a very difficult situation when they're trying to prove that there is a non-compliance or the quality is substandard in the goods that they received.
So Alfred, in resolving the dispute that you have, is it really very important to be understood?
Yes. And understanding is always the key, because a lot of misunderstanding or miscommunication in the very beginning of the contract can lead to a lot of dispute in the later day. And actually, when disputes arise, sometimes it is all because of misunderstanding of each other's position that lead to a massive litigation that costs both parties a lot of time, money, and at the end of the day, a lot of stress, which is totally unnecessary. Your parties can get together and talk about the differences and resolve the dispute. And at the end of the day, it's of both parties' benefit.